So now, in this particular chapter, which is judicial system in India. Now, in this, what kind of questions we can expect in the exam? So today, even though I have shared some expected mains topics, you can still make them dynamic by adding some more segments. For example, I told you that fundamental rights topic is inherently linked with the judiciary because it is they who will protect the fundamental rights. The way UPSC is trying to change the way it asks the questions, sometimes it directly asks traditional questions by giving concept like, explain the concept of PIL and how PILs have strengthened judicial activism, something like that. Or they will ask questions like, what is the role of judicial review in safeguarding constitutional supremacy, like that. They are asking questions like evaluate, or you can say just the role of vice president as in that question, in the other chapter, okay, chairman of the Rajya Sabha, what kind of role he is performing. So many times there is a judicious blend of questions from both very direct questions, and sometimes they ask application oriented questions. Even in direct questions also, you have to always give some latest examples. And in questions where they're asking you to, for example, I'll tell some question. Evaluate something like this. 150 words question was asked by UPSC. Evaluate the role of Supreme Court in constitutionalizing environmental problems in India. That means how environmental problems in India have been constitutionalized by Supreme Court, which means you have to give at least 3-4 cases of Supreme Court where they upheld the right to clean air environment, or like polluters pay principle is there, or you have this TN Godavar man judgment is there. I have made a detailed video on recent Supreme Court judgment, okay, Ranjit Singh versus Union of India case, new dimension of Article 21. You can just see, okay, how a bird has expanded a fundamental right in India. Great Indian bustards. They are critically endangered species. Less than 200 are there in the wild. So in the past, Supreme Court has told to construct underground power lines. But then government has told that it is not possible because of the arid areas of Gujarat, okay, and Rajasthan, which is a state bird of Rajasthan. We can't do there because it is completely arid areas and there, and feasibility is not there for having underground projects because sand keeps moving all the time and we can't locate those places. Then Supreme Court modified that a little bit. India has commitments of wind solar power, so we have to have the wind solar powers for them. So India has made that in case any adverse impacts of climate change happens, it is the government who has to save us. So right against adverse effects of climate change has been held as fundamental right under Article 21. This is also a case, Ranjit Singh versus Union of India case. In this case also you can quote, MC Mehta versus Union of India, where the tanneries in Kanpur were polluting the rivers. So there also Supreme Court held absolute liability principle. You are liable even if you are a industry, you cannot release all kind of sewage in the rivers. So it is MC Mehta versus Union of India. Problem is that MC Mehta cases are at least 1 dozen. So which MC Mehta we will not understand. So this is 1988 MC Mehta case. 1988 MC Mehta case. Here the court has talked about absolute or liability principle. That means you are liable for what sewage you are discharging. Fine. So all this can be quoted in which answer? How Supreme Court has constitutionalized environmental problems. That means you can quote this. Or sometimes last year they asked like, how Supreme Court has expanded the scope of Article 21. How it has expanded Article 21 scope. You have to use Maneka Gandhi as a reference for us at starting point, because due process of law has been incorporated in India by judicial precedent, not by the constitution. They refused to add in the constitution in the assembly. Then from Maneka Gandhi case, then what all dimensions got added to Article 21? So it could be anything, like it's a very big article. If you see my notes, 40 pages fundamental rights notes I have given in the PDF what is shared with you, Google Drive. 40 pages fundamental rights is there. In that I have given detailed cases of Article 21, which may include as simple as, regarding right to life is equal to right to suicide or not. Gyan Kaur case, Ratnam case is there. Aruna Shanbhag case is there. That one case you can quote. Then in 21 also we also have the concept of what? Ram Leela Maidan case, right to sleep is also fundamental right. Baba Ramdev will go in chunni wearing lehenga and all that. He will run away when police comes to arrest him. Ram Leela Maidan case, right to life also include right to sleep also. You cannot disturb people in the sleep. So right to sleep is there. Right to privacy, Puttaswamy case also is there. And all these components, at least 4 or 5 cases, you can explain that how Supreme Court has expanded the scope of Article 21 over a period of time. Now, this is the dynamic questions which we can expect from fundamental rights and judiciary, because it's intertwined together. So, but because it is a daily test, I gave some questions which are standard questions. Okay, what is, like, we have to know what is judicial review, what is activism, what is PIL, what is the collegium controversy, and tribunals also are there. So let us see one by one each question. There could be some overlappings in the answers or cases what you quote in this second and third and fourth questions. But you have to be very careful where to use activism kind of PILs question things, and where you have to use other cases also. I'll explain to you. Now, first question is evaluate. That means you have to discuss and you have to give your suggestions also in this question, evaluations. Didn't say critically evaluate, they didn't say, but evaluation also has an element of some criticism. It also has elements of suggestions also. Controversies and criticisms regarding the collegium system, and suggest possible reforms to address them, which means this question is expecting you to first highlight what are the issues of collegium system and what is collegium system, and do you have any mechanisms to solve this collegium system or the judicial appointment system. Fine. So your answer structure for this particular question will be based on, first you have to define what is collegium. Ekko rasta time out kada. Fine. So today we'll go somewhat quickly only. So you will start with collegium system definition, which means collegium system is a method of judicial appointments. Okay, in for higher judiciary is the keyword here, because it is not something which we use for all types of judiciary. It is a method of appointment of judges to the higher judiciary. Okay, that is one simple line you can write. If possible, in the same paragraph you can also add it has evolved in so and so case, but when I'm adding some extra input, I would rather prefer to add next line. In next line I can add it has been evolved in India in which case. Okay, first judge's case. I'll forget because okay, last I was going through my answer copy, by mistake 40 article has come as 42 in panchayat something. Okay, please, I think already you can realize that. Okay, TPSPs was there no question there. I think instead of 40 some 42 got typing error happens. Okay, so 42 is different, 40 is different. Just I remembered just now. Okay, so alanti discrepancies emana unte you can just let me know. I can tell everyone. Okay, I just saw myself and I found it. But anyone knows 40 article is about organization of panchayats, higher judiciary. Which case this particular collegium system has evolved. Okay, collegium system evolved in Supreme Court Advocates on Record Association. If you can't remember all the entire title, second judge's case 1993. It is where Supreme Court collegium system has come. Then it got the 3 judges became 5 judges in the next third judge's case. So you can explain some factual point that the collegium system has evolved. Okay, evolved in second judge's case. Second judge's case. It is Supreme Court Advocates on Record Association versus President of India. Okay, second judge's case where a body of 3 judges which అని చెప్పేసి రాయొచ్చు. లేదు అంటే if you want to avoid this, if you want to directly go to that 5 judge bench, you can say the present form of collegium system owes its origin to third judge's case అని చెప్పేసి రాయొచ్చు. Because this judge's case it was 3 judges. Next one was 5 judges case. So you can use that also. Up to you how you balance the statement in short lines. So you can say the present form of collegium has evolved in third judge's case. Okay, where a group of 5 Supreme Court judges and Rasi in the bracket with CGI as the head, okay, will be the body to recommend appointments, elevations and transfers to the higher judiciary. That's it. Enough with the introduction. Now the question is asking you to talk about the criticism aspect of collegium. So before you go to the criticism, you can add one point. Okay, it is not mentioned in the constitution and a word add cheste bauntundi. Collegium, basic structure, okay, these are all new things. PILs, these are all not introduced in the constitution. They came out of various challenges or precedents. Once you give that line that it has not mentioned in the constitution, it has met with following concerns, or you can say there have been following criticisms, or you can say there have been several criticisms and controversies surrounding the collegium system in the following ways. That is the connecting word which we use. And then you mention those challenges or not challenges, criticisms and controversies. All of you can easily understand what are the criticisms. Okay, let's try to expand them. First criticism is that it is completely opaque. Okay, lack of transparency. So because there, every single point where you write, you can write one phrase or one single line. అర్థమైందా? అంటే సింగిల్ కేవలం పాయింట్ వైజ్ ఎప్పుడు రాస్తామంటే వెన్ టైమ్ ఈజ్ ఓవర్, లాస్ట్లో కొన్ని క్వశ్చన్స్ ఉంటాయన్నమాట, హరిబరి రాసే క్వశ్చన్స్ కొన్ని ఉంటాయి. దట్ ఈస్ ఆల్, ఎవ్రీ ఆస్పిరెంట్ విల్ ఫేస్ దట్. At that time, instead of leaving the question completely, you will write like this. Okay, once you sit in exam situation, you understand these points. Appudu emavutuntante, you don't know how much time is left kabatti, and you cannot frame sentences. So immediately what you do in the last few questions, you will write in this way. Writing in this way is far better than leaving the question. You get at least some marks. Okay, you can expand this by saying one line. Okay, why it is opaque and transparent? Because it does not have any it does not maintain any kind of records. Public records are not there. It is not given, or you can say there is no documentation or lack of objective criteria and చెప్పేసి రాయొచ్చు. Okay, that is one thing. Second thing, or you can write the same point in the second other point, and also you can write lack of criteria, and you can say the details are not disclosed to the public and చెప్పేసి రాయొచ్చు. Details are not disclosed to the public. Why they are selecting some judges? After a lot of criticism, now in their website they are mentioning just one line or two lines, but they are not giving detailed discussion what went on beside transferring a person, appointing a person. They are not giving in detail, guys. So that is one point you can write: lack of records, public record, or lack of any kind of record to the public. Third one, as you all know, allegations of nepotism, okay, favoritism. These always are there. You can say majority of the judges, okay, are coming from the family lines and చెప్పేసి రాయొచ్చు, or hereditary and చెప్పేసి రాయొచ్చు. Fine, nepotism and favoritism. Fourth one, what you can write is that it lacks diversity. Very good point. Closed door అన్ని అది సేమ్ బ్రాకెట్ కదా. Lacks diversity. Collegium లో ఏమవుతుందంటే, because most of the appointments of higher judiciary, when we have seen the, of course there is no official data here, but we understand that upper castes are dominating the higher judiciary in India. Women also, you can lacks diversity, you can address that point. If you want to add one more point there, underrepresentation of women. Okay, lack of inclusivity. Again, be careful. When you have a lot of weight in your points, don't dilute by adding more and more. Don't stretch it too much. We have, but official data is not there, is only my concern. Do you have any official data? I was searching for it. Some other independent committees, like organizations, have given the reports. If you ask me judicial vacancies and pendencies, we have official data, because now we have judicial data grid. We can understand the pendencies and vacancies. Pendencies we can understand. Vacancies also we can understand, because every high court has a sanctioned strength and we know how many vacancies are there. But this caste based is not calculated or registered by the government kabatti. But still, if you find any credible government agency or some NGO giving the report, you can still write it. Nothing wrong with that. Accepted. Okay, fine. And that is fifth point. Sixth point, lack of accountability. Okay, there is no accountability for whom they are choosing, why they are transferring, and all that. There is no accountability also. You can expand that particular point also. 6 points you have written regarding the criticisms here. Now what you have to do in the answer, you have to, criticisms and controversies means the same. Okay, and don't be too hung up on every single keyword. They all sometimes have a composite meaning in the question. Ardhamainda? Like I told, explained on the previous day, they're connected towards each other. Like one student yesterday has messaged me, last Saturday she messaged me that, sir, when you gave the question of speaker, you told what constitutional provisions and conventions are there for the speaker, and JPC asked a question. So I gave constitutional provisions and conventions as heading. Conventions we don't write. So student asked me, sir, in all these points, where are conventions, where are constitutional provisions? So I clarified, aisa nahi hai. Conventions means like speaker belongs to the ruling party only. Okay, speaker election is always in uncontested elections. You can write, because see, sometimes when you don't, when you're not able to write exact word in the question, that's why I'm telling you, when you write that connecting line, I told you, the following criticisms and controversies have come on JPSC. That will sustain. Then you can write in the following ways and these points. While ichchinattuga exact other word you can write, or you may not write also, because many times what happens is, like you will write just like in the next enti annattuga what's next లా ఉంటుంది కదా, then అని చెప్పేసి ఇలా you will write like sometimes some questions will demand then way forward what happens అన్నట్టుగా కొన్ని ఉంటాయి అన్నమాట కొన్ని questions కి, అలా కూడా రాయొచ్చు, nothing wrong with that, which means it's like a no way forward or then and I just give a reference here, then అని చెప్పేసి then who will decide dispute అని చెప్పేసి 1 2 3 4 points అలా అర్థమైందా. దట్ ఈస్ ఓకే, యూ కాంట్ పోస్ క్వశ్చన్ ఇన్ ద ఎగ్జామ్ టు ద ఎగ్జామినర్ గైస్, డోంట్ డూ దట్. దెర్ ఈస్ నథింగ్ లైక్ a suspense you can leave in the conclusion. You can never have such kind of open-ended answers. You always have to end by taking some stand. Stand in the sense ki you are telling where you are in this particular topic. Like you are ending the answer by saying that some summary you are saying, or if this kind of questions are there, you are trying to emphasize on some way forward kind of point. That is, we'll say no, like it is very important to ensure that why the issue is there, because executive appointment always creates issues. That you can write here also guys. Collegium lo ibbandi entante inkoti, it totally undermines separation of powers. We can write this point. Why? Because it does not give, it gives unlimited power to the judiciary. Nowhere in the world judges appoint judges. That's a very good point. Suddenly good question. Okay, it undermines separation of powers. So ante ikkada ee component last ending lo you can write, okay, that when you conclude the answer na ki how it is important to balance judicial independence along with the okay giving chance for the executive in the appointment of judges. Balance cheyali. Idi enduku vachinadi, it emphasizes what guys? Judicial independence. The reason why in my answer I also gave in this criticism NJAC I gave. The problem with collegium is that even though NJAC has come, the Supreme Court has rejected the NJAC. Okay, Judicial Appointments Commission. That is also one point you can write there. Ho gaya. Now second part of the question is what? Suggestions and reforms and measures. Are you understanding all of you? Okay, now let us go to the suggestions or reforms and measures. So you can say it is important to address the controversies and the following are the suggestions and reforms. Okay, Nikhil, delays in appointments, meritocracy suggestion you can say. Supreme power to judiciary. This is a good point. Limits the role of executive and legislature. Concerns about adi criticism lo rayachu, measures lo rayali ippudu. Independent. Yeah, your points are accepted. Measures required. First, you all know that there is something called as memorandum of procedure. So we can say we can reform the memorandum of procedure so as to include the details of how you actually choose those judges, ela appoint chestunaru, what is the criteria for them, you can write there itself. Okay, and second then you can say include, that means provisions to include a balanced representation, provisions for inclusion of diversity. Okay, inclusivity, that is one thing which you can add, which means you can fix some number or at least some criteria where you will appoint people from women, marginalized sections, etc. you can add. That is second point. But in a very smart way, because if it is similar to that, a person who evaluates in a few minutes will understand that it is entirely same, the criticism as well as the measures. You have to show certain difference in the measures required. Okay, where you will also add some other countries, I don't know, we'll add other countries best examples, we'll add reports of committees, commissions chestam kada, avanni add cheyali. Fine. So it is one point. Provision for inclusivity reforms, this one. And also what we can say is adopting best practices from other countries. Adopting best practices from other countries. What are the best practices? For example, you can use here itself in USA, UK, how they appoint. I mean, like USA, it is the president who appoints or nominate Supreme Court judge or appoint judges, and Senate will ratify it. In UK, it is the 5-member committee is there, okay, which has people from the judiciary and bar. Bar means not Chandni bar. Okay, bars, judiciary, bar, and people, there are some laymans also from all Scotland, Northern Ireland, Wales, England nunchi 1% they will take in the depend on the composition, they will take into the 5-member commission. They will select the Supreme Court judges and they will tell the presided by the President of Supreme Court. In India, we and USA we call Chief Justice and all that, no, Justice. There in UK they call the President of Supreme Court. Okay, and that person is presiding over all these commissions. He will tell finally the name to the Prime Minister, Prime Minister to the Monarch, and Monarch will sign. No need to write all that nonsense here. Only one small point here. In Germany, is very peculiar. We may or may not adopt. Half members by legislature, half by judiciary. Okay, that is one thing. Half by legislature plus half by judiciary. Yes, examples you are saying in the answer here, guys. Okay. Some suggestions. Uncle judges syndrome. Okay. Yeah, good point. That is a syndrome affected by collegium system. Public disclosure for accepting and rejecting. Transparency in criteria is accepted. Okay. Public disclosure. That is the way forward. That is a criticism and way forward. They are not telling why they are rejecting some people. Like the Tahila Ramani judge was there. Suddenly transfer from Madras to Meghalaya, where only 2 judges are there. So no reasons were told properly that why she was sent away. They told she is not coming to the office on time and this and that, but they are not valid reasons. That is not good. Muralidhar, of course, here it is government problem here. Muralidhar was the judge when Delhi riots were going on, and he was very proactive. But what happened was he was suddenly transferred, okay, and later he was recommended from High Court to Supreme Court, but central government sat on his file for a long time and he retired recently. So ఆ పాయింట్ కూడా యాడ్ చేయొచ్చు, అంటే డిలేస్ని టైం లిమిట్. ఓకే, ఐ విల్ సే దెర్ షుడ్ బి ఏ టైం లిమిట్ ఫర్ ద గవర్నమెంట్ టు యాక్సెప్ట్ అని చెప్పి రాయొచ్చు. ఆర్ we can also say one more point, time limit తో పాటు reasons for rejection of candidate. Okay, time limit for appointments, because we can write the example there, guys. చాలా వేకెన్సీస్ ఉన్నాయంట కాలేజియం స్లోగా ఉండడం వల్ల. May 2024లో 29% of the vacancies are there in the high courts in India. Total vacancies in Indian high courts is 29% in May 2024. So what you can say is that time limit should be there to approve, and if you don't approve, there should be reasons of rejection should be clearly communicated. This is also another point. Reasons of rejection have to be communicated openly. Best practices already we wrote. Reforming MOP we wrote. So all the points what you want are on the board. Okay, fine. So this you write, and then conclusion is, while the collegium safeguards the judicial independence, it is important in order to ensure inclusivity. Okay, same other words, in order to ensure inclusivity and inclusivity of board on the and to support the, or to say we can say to include the executive and or legislature, or let's say hence it is important to it is important for the collegium because of judicial independence. However, to address the concerns of inclusivity and transparency and accountability, the collegium system should be suitably be reformed. And JPS Raj. Okay, reformation we can ask. Or if you don't propose any radical solution that we need to abolish collegium system, don't write like that in the answers. Okay, mari lopsided ga suggestions undakodadu. Mottam cheppi last weekend and JPS, it's not good. You can say that it has to be suitably be reformed to address these issues what we just spoke about. That should be a conclusion. Okay, any other points you want to add? We can go to second question. Okay, second question and third and fourth we can breeze through very quickly because they are all connected to each other, but there is some small difference. I will tell what difference is there. Activism and PAL are related to each other because PALs have increased the role of judiciary, which is judicial activism. Judicial review is a separate question. Now where to add what kind of case, I will tell you. In the case of examine, that means you have to examine, means you have to discuss in some more provisions regarding what is judicial activism, not just definition. How does judicial activism impact the balance of power? What I made one small tweak in the question is, how does this judicial activism is undermining this delicate balance of legislature, executive and judiciary, which means you need to quote those decisions by Supreme Court or High Courts which has upset the balance of these three organs. Don't just randomly quote anything. In the each cases you explain how it upset the balance, how it undermined the powers of legislature, how it undermined the powers of executive. I think you understand the point. Okay, so that means you have to always see the question, read it multiple times to see what is the central demand. Okay, first start defining what is judicial activism. Now I will not write. Okay, judicial activism is what? One word I will write here, this proactive role. This is one point. Proactive role played by the judiciary, okay, in interpretation of laws and safeguarding the fundamental rights. Why they are in front foot batting they are doing? Because they want to save our fundamental right. That is, judiciary is called custodian of our fundamental rights. No? Custodian of constitution, guardian of civil liberties. That is why they are actually on front foot. Means proactive role. Activism means proactive role. Not the usual role. Being proactive role. Why proactive role? For time pass? No. Because of protection of fundamental rights. Interpretation of the laws or the orders by the executive. That is what you can write. There are some value addition points which may sometimes fit or not fit, but I think when Lakshmikant sir added these things in the Lakshmikant book, now his own book, I think it's better. In generally PSR classes, I will tell which are the scholars who brought these concepts. I thought that is not important for general studies, but now in Lakshmikant Polity also he brought that. For example, judicial review concept has come from which country? USA. Okay, other point, not the answer. This is value addition points. USA. In which case, so Marbury versus Madison case. Now everybody is quoting these cases. Okay, Marbury versus Madison case, 1803. In this case, Supreme Court Chief Justice, US Chief Justice, okay, Marshall, he held that whatever the Congress passes the laws, we can review it as Supreme Court of USA. That is what he told. 1776 they got independence, 1787 Constitution was written, 89 they implemented, and within 14 years, okay, they got this chance to bring a new concept called judicial review. So you can, if possible, quote judicial review evolved or we have borrowed from USA in any question. Points rakapothe gurtundakapothe, okay, you can add this kind of trivia. Okay, Marbury versus Madison case. Marbury cigarette, Marlboro, what is that? I don't know. If you have any reference or jokes, whatever, you can connect always. Okay, unda Marlboro nadi. Fine. So that is one thing which you can quote. Judicial activism word has been used by a person called Arthur Schlesinger Jr. Arthur Schlesinger Jr. He used the word judicial activism. That point you can add here. PIL concept emerged in, again, was used by a professor who was seeing that there are some very good lawyers who are actively taking up public cases and fighting in the courts. Those who can't afford, those who can't go to the judiciary, some lawyers pro bono without any money, okay, they are going and taking up important cases. So he called this practice as social action litigation or public interest litigation. Social action anu cheppochu because it tries to bring some social change or social reforms also. So that person's name is Professor Abram. Shahrukh Khan ka beta naam also, bete ka naam bhi Abram hai. Okay, Abram whatever, not Abraham, it's Abram. Abram Chai, not Chais, Chais, Chayes, Abram Chais. These are some trivial facts which may or may not suit in the answer, but nothing wrong if you just write one single line. Kuch nahi hoga. Okay, fine. But don't write the story there. Just as a factual point, you can quote. Ab yahan pe when you wrote introduction as proactive role played by judiciary in saving the or in safeguarding the fundamental rights or in the interpretation of laws. Now the question is asking what? Question is asking for examine the concept. Now you have to explain like why judicial activism has become very important. Why it has become very important? You have to explain the causal reason here. Judicial activism has developed in India. Okay, we can say in the concept of like PILs have come. No, after the emergence of the concept of PIL, judicial activism became very prominent. Okay, and you can say judicial activism owes its judicial activism has increased because of the reluctance, or we can say the ineffectiveness, okay, of the other two organs of legislature and executive. That point you have to write. When these organs fail, then judiciary will come and fill the picture. So you have to examine antunar kabatti definition to part you have to give also the reason like why judicial activism has become very important. Arthamainda? Judicial activism, why it became important? Because one thing is the reluctance, don't be very harsh also, the reluctance or we can say or the ineffectiveness of the other two organs, okay, has prompted judiciary to take up the cases or we can say take up the cases involving fundamental rights of citizens, full stop. After the concept of PIL emerged in the 1980s in India. Even the first case, we call it as Hosanara Khatun 1979, but 80s was the age when PIL's concept were popularized by Justice Krishna Iyer and Justice Bhagwati. So after the concept of PILs have come, judicial role activism has increased. And cheppesi rayachchu, nothing wrong with that. Okay. Then after writing those one paragraph, what is the question is saying? How does judicial activism impact the balance of power between legislature and judicial or executive? Now here you have to give some cases where Supreme Court's decisions have impacted the functioning of the legislature and executive. So let's take up the examples. You can say the Carnatic line. The frequent practice of judicial activism has undermined the role of legislature and executive in the following ways. Okay, or affected the functioning or affected the powers of the legislature, executive in the following ways. First case, what case? Go to Indira Gandhi. Indira Gandhi, because where they have Supreme Court or court has told that you can't do this. Golaknath case. Okay. Online nostuna comments. Okay. Right. See guys, two things to remember here. Legislature where it has affected, executive where it has affected. And judiciary రావడం వల్ల ఆ రెండు ఆర్గన్స్ ఏవైతే ఉన్నాయో వాటికి ఎలా ఎఫెక్ట్ అయింది. So legislature Indira Gandhi was like, I will amend whatever I want. Parliament is the will of the people, so I can do whatever I want. Judiciary told, no, you can't amend fundamental rights. Okay, which is that case? Golaknath versus State of Punjab, 1967. Okay, this is one case. And also you can write Keshwananda Bharati case, 1973 Kerala. These two cases have affected the amending power, okay, of the Parliament. Because in these two, no need to expand, these two cases, what they have told, Parliament's amending powers are having limitations. You can't change the basic structure, they have told. This case has told that you cannot change the fundamental right, it has told. Okay, that is one case. Or if you want to add, up to you guys, you can add all legislature, executive together. They're not asking specifically side headings of where it impacted legislature, where it impacted executive, they didn't ask. But for your clarity purpose, if you want to be very clear, you can write both. Like for example, you can say where it undermined legislature, you can write one heading. Okay, one heading you can also write where it impacted executive, you can write. For even more easier things, put a box and write legislature and executive. It's up to you. Okay, fine. So ye do kya hai? Legislature has been impacted. Inka, any case? Huh? Legislature. Indira Sawhney versus Union of India, 1992. Legislature impact. See, review, activism, overreach and restraint, these four have some connecting things. Judicial review is the basic role given to judiciary by the constitution to review the laws passed by legislature and the orders by the executive. If you are very proactive in doing that, if you are very proactive in saving the fund, reviewing the laws, if you are very proactive in reviewing the orders, that is called activism. Activism need not be always PIL based. Activism need not be always based on PILs. Activism can be based on judicial role itself. Like when judiciary was seeing every day Kuldeep Sengar, the BJP MLA in UP, raping and the girl, and her father went to complain in the police station. Even he was beaten up and he died there. And these guys, one by one, lawyer also attacked in the when you go into the court, the entire car has been attacked by the truck. Some persons in the car died, family members died, lawyer beaten up. It's like a movie it was going on. Then the court has seen this in the papers and they suo moto reacted and they told CBI inquiry has to be there. Now this is not PIL. No? This is something where judiciary itself involved into the case. Delhi case. Delhi cases means what? Pollution case. Graded response action plan. Supreme Court was very proactive in that. Banning of liquor on the highways. So we can, it's not always PIL based. PIL is a tool to increase judicial role or to bring attention to their the cases, whatever is there. Arthamainda? So review anedi proactive role andi. Emoutunante aa review proactive role cheyadam valla, activism valla, if it is entering or encroaching into the domains of legislature, executive in an unwanted way, then we call it as what? Judicial overreach. I got the point, right? Like judicial overreach means encroaching on the powers of the other two organs is overreach. When Ashwini Upadhyay, the BJP leader, always goes to Supreme Court every day morning after breakfast, dosha, idli, chai, he will go and file PIL in the courts. That is his job. So one day he filed like PIL saying that we want uniform civil code all over India. Then Supreme Court told central government, what is your opinion on this? They told, sir, already he filed this PIL in Delhi Court. There we told our response. Again he is filing case here, please cancel it. मतलब क्या है? Judiciary is not saying that we will only allow this uniform civil code. They told it is up to the center government to frame the law on that. It is called judicial restraint. Means I am not involving. It is their job. Same-sex marriage, it's very complicated. I will not involve. Let the parliament make law on same-sex marriage. I think there is some fine thread between review, activism, overreach, and restraint. Overreach means what? Banning, asking people to sing national anthem when you in the theaters. Very famous cartoon which symbolized this. The cartoon showed like this. All files are lying like a pyramid. Okay, from that one hand is emerging, judge's hand, and with a pen. And one there, very far, there is one file is there. This is all pending cases are there. One hand is emerging like this, and that hand is going there like Fantastic Four and signing that file. That file is what? Singing of national anthem. Array, this many, you are completely buried in the pile of all cases, but your hand is coming like Fantastic Four and it is signing national anthem case. This is not required. Kind of overreach anamata ivanni. Okay, banning of alcohol on the national highways and all that. We'll discuss all those cases. Okay, fine. 7 o'clock is almost. One more case where Supreme Court put a stay on farm laws. When farm laws issues were being going on, Supreme Court put a moratorium. Moratorium means what? It put a hold. It put a hold on the laws. Then Modi apologized and he took away those laws. But Supreme Court actually, when people went to the court, they put a ban on the implementation of those farm laws. Moratorium on farm laws. Ab ye ho gaya. You can write, okay, where it has affected legislature also. NJAC has been cancelled and all that. You can quote. Now executive. Chala unta executive. Huh? Sheila Bhasina, Anuradha Bhasina. What is that case? In prisons, huh? Okay. I didn't hear that exact case. Ushanara Khatun case is regarding, but violence against prisons, executive, how it has stopped, how it is affecting. What is the order? Don't know. Okay. My question is, you have to give those cases where it has undermined or taken away the powers of executive now. Legislature already over. Executive mein kya hai? Undermined. I would want where it is like putting a kind of check. So I gave one case in your answer. It is Bombay High Court Jolly LLB case. Bombay High Court Jolly LLB case, even though CBFC, Central Bureau of the Board of Film Certification, it already gave the certificate of screening for the movie. Once it gives, nobody should stop. But Bombay High Court, because it's a movie regarding judges, okay, some insulting things they have seen in the movie, and they asked some 2 scenes to be cut. Now here, executive is being undermined. Okay, executive body, when it has duly passed a movie, the judiciary is coming and trying to scuttle it. When CBFC, statutory body itself, has passed a movie for screening, fit for screening, but judiciary finally in the last second, Bombay High Court is asking for trimming of those scenes, 2 scenes where judges are shown in a very bad light. This is a case where you can say it is affecting the powers of the executive. Okay, never heard this. Bombay Jolly LLB case, Akshay Kumar and that one more Arshad Varsi movies there. Telugulo వచ్చిందా ఇది? అన్నీ వస్తాయి కదా అన్ని మూవీస్ రాలేదా? ఓకే ఫైన్. కామెంట్స్ ఏమైనా ఉన్నాయి? ఇంకా 5 comments are there. In either case, Indira Gandhi Raj Narayan case, 39th amendment invalidated. That is again parliament here. MC Mehta Vishaka guidelines. Okay, you guys are saying these cases to me. Minerva Mills case. Okay. I think I should have read this at that time itself. Fine. Indira Gandhi Raj Narayan case. Executive, I found one. In court, executive power has been scuttled. Banning of crackers. Banning of crackers in 2020, complete ban they have imposed. Later they modified to green crackers now. Their executive already passed the policy, gave the licenses for everything, but finally Supreme Court in the last second has telling that what? Ban the firecrackers in 2020. This is also a overreach, or we can say activism which has undermined the powers of the executive. When these people have approved the policy of firecrackers, when they gave license for the industries, when they gave license for the manufacture and sale of these particular firecrackers, last the Supreme Court vachesi arbitrarily suddenly saying that all firecrackers are banned. Now this is impacting the livelihoods of people, of course, and also undermining the powers of the executive. Like this, some 5 cases are there, 5-6 cases are there. These cases, I don't know, difference is there, guys. You have to exactly use those cases. వాళ్ళు చూస్తారో లేదో మనకు తెలియదు కానీ అట్లీస్ట్ ఫర్ అవర్ కాన్షియన్స్ You should use those cases where you have to tell in the every case ki how this particular case has undermined the powers of which organ. Are you understanding or not? Farm laws are duly passed by legislature, but it is a judiciary which has put a moratorium on that. Imagine laws passed by the parliament and judiciary has put a moratorium on that. Okay, or let's say executive approved the firecrackers policy and judiciary putting an end at the last minute. Executive CBFC already passed the movie for the screening and suddenly Supreme Court, Bombay High Court asking to cut 2 scenes. These are considered as unnecessary intrusions of the judiciary into the powers of legislature and executive. Now, what is the question saying? Second question. Okay. Answer is over. Now, what you can say? Some way forward you can give. Until they didn't ask, but still it is better to end the answer on some way forward. So what is the way forward here, guys? The way forward here is, while judiciary has been given the role of safeguarding the individual rights, and you can use the words like protecting federal equilibrium. Protecting federal judiciary, basically, guys, why it exists is because it of course will interpret the laws, but it also saves our fundamental rights. It maintains federal equilibrium by, when you read the answers on center-state relations concept in your classes, you will see that an independent judiciary is important for federalism. It's a federal feature. Why? Independent judiciary ఉండడం వల్ల ఏమవుతుంది? What happens? If judiciary is compromised, then federalism will be affected. So I added that in the third answer of judicial review. I'll come back to that point. Key judiciary, you can say judiciary occupies an important role, or you can say judiciary plays an important role in safeguarding individual or fundamental rights and also protecting constitutional supremacy. However, it has to be tempered. Tempered means koncham tagginchali. Okay, taggedile cheppakudadu, temper cheyali. Okay, it has to be tempered with, or we can say it has to be tempered with the following and cheppesi, or way forward following and cheppesi 1 to 3 points rayachu. Em rayachu? Okay, to as maximum, or you can write in this way also, like way forward and cheppesi rayachu. If you don't want to write the sentences format, you can write way forward, at least 2 or 3 points you can write. What you can write here, same, I just told you the points. Okay, judicial restraint and cheppan kada, as far as possible judiciary should exercise the restraint and not interfere into organs or the functions which are properly assigned to other 2 organs. Vere 2 organs ki evaithe functions assign chesaro, in that as much as possible exercise restraint. Second thing, judicial activism, you can say. Okay, judiciary should have same. There is not much reforms we can suggest here, because it is not a dimension where judiciary should be holding the accountability when they, or we can say farsightedness, or we can say accountability when they give this kind of decisions. Because suddenly if I say ban the firecrackers, where is the judicial accountability over this? Like, what happens to the livelihoods of the people? You are not answerable to that. What happens if you ban the liquor on the highways? You are not answerable to the loss of livelihoods here. So judicial activism has to be tempered with accountability mechanisms also. Many times this comment which is being told, like people who are living in ivory towers pass judgments without having ground reality and చెప్పేసి ఒక criticism ఉంటుంది judiciary మీద. So ఆ point రాయొచ్చు. ఇంకా what else? I think I didn't give in my answer the way forward, but still any other points? Activism key points. Okay, but the main reason issue came because other 2 organs are not working. That point we can write in the way forward kada. Like sensitization, we can say, I think I gave or not, I'm not sure, but there is one point which we can add, guys. Very 2 organs, they're not doing their work, that's why we are having judicial activism. So you can say that what or you can say institutionalization of mechanisms in executive, or we can say executive should be framing the laws and policies, is one word we can use. Somebody can help me out. Judges, supporting judges, that is fine. No, see guys, okay, wait, there should be narrow demarcation between activism and overreach. That is a conclusion, Nikhil, which we can use. That is a conclusion which we can use in the last, that there should be demarcation between overreach and activism. That is one thing which we can use in the last conclusion. Okay, but if you want, see guys, one thing, just don't get confused. Our answer usually ends at where we wrote the cases itself, and before that we explain judicial review and the cases. You can straightforward end your answer by just one line by saying that judiciary plays a proactive role in the saving of fundamental rights and reprieve. However, the balance has to be maintained between the activism and overreach and reprieve. End చేసేయచ్చు answer. But some extra points if we can add, that will make some good impact in way forward. In my answer I didn't give way forward because it was not intended here. So I would add here one point here. That means the other organs, okay, other organs should fulfill their roles or fulfill their constitutional mandates. Yeah, what point you're saying? This is one more point. Yeah, same point. Inka, last one point. Any other point we can think of? Done? No other point? Judicial activism is like peacemaker and judicial overreach is like a trespasser. Judiciary shall settle to the that guy has told, no? Go, yes. No, it's fine. I'm asking for one keyword. Otherwise, it's okay. You can hear itself. I'm also not able to think of in levu points inka చెప్పడానికి ఏం లేవు అంటే pertinent to exactly activism ఇంకా ఏం points లేవు. After this, that conclusion what I just told you, you can write there itself. Guys, time is getting over. Abba. Critically evaluate the role of judicial review in safeguarding the fundamental rights. In this kind of question, you can start with that Marbury versus Madison case, judicial review. Judicial review define cheyandi. It is reviewing of what? Constitutionality of laws and executive orders. Tell there one line, it is not mentioned in the constitution, but you can say it is implicit in the articles, like you can write like this. Okay, it is implicit in those articles. Uske baad, where judicial review, in what cases we use? Okay, first case, if it is against fundamental right. Okay, second point, if it is repugnant, if anything which is going against the constitution, then also you can use this judicial repugnant to constitutional provisions. Idoko point. Okay, third thing, if it is beyond or outside the competence of the authority which has framed it, ante ultra virus laga idi mee paridhi kaadu, you should not make this law, unnecessarily you have made it, idi mee paridhi raadu. Okay, outside the competence of the authority which has framed the particular law or order. Done. Okay, done. Now this is the introduction and the supporting point. Ab yahan pe we have to go to critically evaluate in safeguarding fundamental rights. Now when you go to this particular answer, here you have to use very easy answer, because you just have to use all those cases where Supreme Court has saved the fundamental rights. Now here no need to make subheadings because they didn't ask different dimensions here, but in PIL I will have to add subdimensions. I'll come back to that point. Difference is there. Judiciary has been proactive in safeguarding the fundamental rights of the citizens in the following cases on JPSC, in the following ways on JPSC. You can mention at least 5 or 6 cases. Okay, fundamental rights cases, what are there? Dozens and dozens of cases are there of fundamental rights. Now tell me what cases you want to add. You can add Maneka Gandhi case to talk about versus Union of 1978 case to talk about a person can travel, right to travel abroad is there. Or second case which you can write. Let us go year by until like chronological eldam manam. Okay, 78. Puttaswamy 2017 case it is there. Okay, uske baad 1978, and then I can go to fundamental rights, okay, of citizens. 19 let's go with article 21 is over. Article 19 में freedom of speech cases तो है. We can add this case. Shreya Singhal is again 2015 case. Okay, I take your point. Puttaswamy, right to privacy 2017. Shreya Singhal, freedom of speech expression 2015 is there. These two you can add. First one what I told you is Maneka Gandhi case you can add. There are some cases which you can use in PIL also and here also, which is Hussain Ara Khatun versus Home Secretary Bihar case in which 40,000 prisoners were released. They were under trials. Right to speedy trial was held as a fundamental right. 40,000 prisoners released by one single judge. Okay, the judgment by the court. Sunil Batra versus Delhi administration 1978. In this, prisoners also have fundamental rights, the court has told in India. Okay, that Sunil Batra, in Tihar jail, he has seen his co-prisoners who are on death row. Their family members are coming to meet him, but prison authorities are not allowing them and they're asking for bribes. They refused to give the bribes, and this prisoner was beaten up very badly, black and blue, and upside down he was made. Rods were inserted in his back, and all that torture he has seen. Sunil Batra wrote a letter to the Supreme Court, and then finally court has question before the court was, do prisoners also have fundamental right? Yes, Article 21 applies to prisoners also, and action was taken against the authorities there. Is you right? Sunil Batra versus Delhi administration. Hussain Ara Khatun versus Home Secretary Bihar case in which speedy trial was fundamental right. How many are over? 1, 2, 3, 4, 5, 6. Okay, anything guys. Aruna Shanbog versus Union of India, passive euthanasia was allowed. That is one more case is there, and one more case, Nalsa versus Union of India, in which third gender was considered as a third gender also was recognized by the court. Nalsa case. Okay, and Vishakha versus State of Rajasthan, in which sexual harassment at workplaces guidelines were given by the court. In ఉన్నాయి cases చాలా ఉన్నాయి, ఇవి 7 కాదు, ఇంకా వస్తూనే ఉంటాయి cases. All the cases where you can think of where citizens' fundamental rights have been safeguarded, that you can quote. I know 7 cases. Any case, guys, but make sure don't say Kyoto Holohan case. Kyoto Holohan case is speaker thing. Okay, అర్థమైంది the point. ఏ cases చెప్పాలి ఇక్కడ? ఫండమెంటల్ రైట్స్ని కాపాడే కేసెస్ చెప్పాలి. సో ఇక్కడ ఫండమెంటల్ రైట్స్ అంటే స్పెసిఫిక్గా మెన్షన్ చేయొచ్చు. పుట్టస్వామి 21 ఎక్స్ప్లెయిన్ చేయొచ్చు. Shreya Singhal Article 19 clause 1 subclause A చెప్పొచ్చు. Okay, and Article 21 for Sunil Batra as well as Hussain Ara Khatun, State of Bihar. Okay, and then Maneka Gandhi, again Article 21 is there. One more case, Aruna Shanbog also Article 21 is there. And apart from that, that Shafin Jahan versus State of Kerala is there. Shafin Jahan case means that Hadia case, right to marry a person of your own choice is a fundamental right, the court has told. Kerala case, that girl has married one Christian girl married one Muslim guy, and it was a big issue. Kerala High Court separated them. Father gave complaint of kidnapping. Supreme Court later told that no, you cannot separate them. Every person has right to choose their own partner. Okay, Hadia case and Rayacho, HADYA, Hadia case. That is for Article 21, right to marry a person of your own choice. Ivanni cases lo just case maatrame rayakunda, you have to explain the one line. Okay, one line each. Why one line each here? Because in this answer you are trying to tell how judicial review has saved the fundamental rights. So don't just mention the case and leave it here. At least one line or half phrase ana rayandi akkada. Ante in this court has upheld so and so article and held this as fundamental right. Or Bijo Emmanuel case, in which right to freedom of speech includes freedom of silence also. Okay, State of Kerala case is, that girls are not singing that national anthem case, that is Jehovah Witness case it is called. Wherever you write the case, guys, some 1 or 2 sentence if you write, that is the explanation of your answer of how judicial review has safeguarded the fundamental rights. Chalo, then what is the question? Critically safeguard. Critically evaluate the role of. So you have written the entire cases, and last give a conclusion here. Conclusion name rasar ante, judicial review is a important constitutional provision which is important for 3 things you write. Okay, 1, it is important to ensure protection of fundamental rights, to ensure federal equilibrium. I told you federal equilibrium maintain cheyochu. Third one, to promote social justice. Social justice is one keyword, protection of fundamental rights is one keyword, and third keyword is what? To maintain federal equilibrium. That is also a good point. Judicial review ensures constitutional supremacy. That is one more word you can add. Okay, fine. Chalo, let's go to the next question. 4th and 5th question. 4th question is PIL. Again, some commonalities are there, but guys, one small point. You have to mention in PIL, basic introduction, the public interest litigations have been hailed as a tool for judicial activism, discuss significance and challenges. Significance and challenges. Okay, comments I'm reading, guys. Minerva Mills case is separate. It's different. Nas Foundation, very good. Nas Foundation case, Navtej Johar case. Navtej Johar is 377 na? Nas may they have rejected Supreme Court, and Navtej Johar they accepted. Nas there are two cases. One is Delhi High Court Nas case. Okay, and Supreme Court cancelled this Delhi High Court verdict. That is another Nas case. Suresh Kumar Kaushal versus Nas Foundation case. Don't get confused by Google search. First, Delhi High Court has reduced, or we can say cancelled, some provisions of 377. 377 has different provisions, not just unnatural sex. It also has with children to kotundi, animals to kotundi anamata. Okay, three are there. All 377 has not been removed. Only one aspect has been removed, which is unnatural sex between humans. Okay, that is only which has been removed. With children and with animals, it's still banned. So Delhi High Court ala chesin tarvata, what happened was Supreme Court to judge bench has reversed it. Then the case again went for several years, and in the Navtej Johar case, again Supreme Court has doctrine of prospective overruling they have used, and they overturned it their own previous judgment, and they told 377 some provisions are unconstitutional. Okay, that is the case, guys. Telsa Navtej Johar case. 377, all of you know 377, no? Today in India, homosexuality is not illegal. Today in India, same-sex marriages are allowed, but the only thing is same-sex marriages do not have legal sanctity. Today only I was seeing one news. Two women have got married, it seems. Okay, in India, some news came today. Okay, marriage is possible, but the only thing is legal recognition is not there for the marriage. Okay, chalo, done. PIL, what will you write in the introduction, guys? Same. PIL concept. PIL also called as, first you write public interest litigation bracket PIL, also is called as social action litigation. Okay, it is a what? What is it? What is PIL? Define change. Okay, it's a legal instrument. Very good point. It's a legal instrument to words. That's what I was saying. To address the what? Any kind of public injury, any kind of public to redressal of public wrongs. Public word enduk important. That's what I'm telling you. PIL. P word is here what? Public interest litigation. The difference what you have to show in the answer here is this PIL is a concept is not because of my landlord is harassing me. Okay, or not because somebody has stuck my vehicle in the traffic. No, this PIL is because of to redress any public grievances or public wrongs, public injuries. That is the chief legal instrument. It's a vehicle, or we can say it's a mechanism which tries to ensure justice for the redressal of public wrongs. It ensures justice, or it tries to seek justice in the cases of public wrong or public injury. And Rasi, you can say it was first coined by Professor Abram Chais to describe the practice of lawyers proactively arguing for cases which involves public interest. Until lawyers proactive public cases they are trying to fight. That is the practice prescribed by Abram Chais. Full stop. Next sentence immediately go to origin of PIL. There what you write is, you can always mention some small point and you can say and you can write there PIL is not mentioned in the constitution. It has emerged for the first time in India. If you know, it's okay. Otherwise, I'll tell you. Mumbai Kamgar Sabha case. Mumbai Kamgar Sabha. Big name is there. Mumbai Kamgar Sabha, Abdul Bhai, Faizullah Bhai versus others. So no need to remember all that thing. Just Mumbai Kamgar Sabha case. In this, Justice Iyer was trying to understand why can't we wages for not given for his workers. Who should argue on their behalf? They are not competent to always argue for themselves. So there should be something where anybody can file a case. No, why should only the people affected should file the case? Anybody should file the case. No need of locus standi. So in this, the roots were sown. Then you can write what? The first PIL case in India was what? It's considered as Hussain Ara Khatun, Home Secretary Bihar. Okay, Hussain Ara Khatun case. Can't remember the entire title, it's fine. Versus Home Secretary Bihar. In this case, it is considered as first PIL case in India. Justice Iyer and Bhagwati has popularized the concept of PIL. That's it, second paragraph. Now the question. How PILs have hailed as tools of judicial activism, significance and challenges. Now write the significance here. Enough details you have written. Introduction is over, origin is over, okay, and if you want, PL can be filed against whom, can be filed by whom, our point రాయొచ్చు. One important line should be there here, because we have to differentiate between PAL and other cases. Once you write this PAL thing here, a PAL can be filed by any person who should demonstrate public interest. Who should demonstrate public interest. In fact, guys, no need for the writing answer. Supreme Court already gave detailed guidelines of in what cases PAL can be filed. They told that in petty cases, in landlord house, house tenant cases, okay, in any kind of motor vehicle cases, you cannot file PALs. You can file PALs in case of wages or virtue, women issues or virtue, or any kind of industrial disputes or virtue, marginalized sections or virtue, child labor or virtue. They have given this specific list also. No need to write here. That means already Supreme Court gives a list of where PALs can be filed. So here you can say PL is filed in public interest. It relaxes the concept of locus standi. And just some additional value addition information for you. PL can be filed where? Value addition points under Article 32, High Court under Article 226, okay, in the Court of Magistrate, when some public nuisance is happening under CRPC 133, you can file in the magisterial courts also, district magistrate or executive magistrate, subdivisional magistrate. They have the option, if some nuisance happening outside, they can order for the removal of nuisance. There also you can file this case. Okay, 3 things. This is not for the answer. This is just a value addition point for you. PL cannot be filed against private authorities. PL can be filed against only government authorities. Then you may ask, then what if private people are doing wrong? What is the answer for this? PL cannot be filed against private authorities. There is one answer for this. Okay. Actually, PL, of course, technically you can't file directly in the respondents. Respondents untar kada, PL against whom you are filing. Imagine some factory in Hyderabad, Patancheru or some other place, some pollution is going on and it is again public interest. You want to file a case against the company. So what here you can do is, technically you can't file PAL against them. What you will do, who is in charge of this? Government State Pollution Control Board. So in the case, you will first file the case in the respondents, first respondents, Government of Telangana, second respondent, SPCB, State Pollution Control Board, third respondent, that company name. This is the process. Okay, in this way you can file PL. Just some validation points only. Let's go to the answer. Now, significance of PLs, I told no. Please mention the subheadings in this case. That makes more value for your answer. What is the first subheading you can write? Let's use in the case of social justice case. What is social justice case now? Just now we discussed, no? Nalsa versus Union of India, that is one case where the third gender has been recognized in India, social justice case. One more thing is there, basic social welfare case also is there, which means Olga Tellis versus Bombay Municipal Corporation. You know, some people, slum dwellers were there occupying the slums in the Bombay. Municipality of Bombay, they have filed, vacate this place immediately. Monsoon is about to come and they asked them to vacate the place. Then these guys, some PL was filed on behalf of these guys. Then the court has told that not complete relief was given. These people who are living in the slums actually are working in nearby factories and all those areas. So if I displace these people from the slums immediately, they will lose not only their life but also their livelihood they will lose. So livelihood concerns were addressed in one of the first cases in India in Bombay, Olga, OLGA-TELLIS. Olga Tellis versus Bombay Municipal Corporation case. Now it is called Brihan Mumbai Municipal Corporation. Okay, Olga Tellis, right to livelihood has been considered as a fundamental right. And court gave some time for the people to be evicted. Olga, OLGA, 1985 some year is there. Olga Tellis versus BMC, Bombay Municipal Corporation. ఇక్కడ livelihood ని కాపాడింది కోర్ట్. అంటే వాళ్ళని అక్కడ ఉండమని చెప్పలేదు. at least till rain, some time to be given for these people to relocate. And now monsoons are coming, kabatti give some time for them. Suddenly if you tell people to go in monsoons, where they will stay? This is a case of, again, social welfare, you can say, or social justice means, I think it's NALSA is very good, and Vishakha guidelines is a very good example for social justice again here. Fine, social justice here. And then we can add one more subheading here, which is electoral reforms. PAL has been filed. Environmental cases, sorry, first one. Third one, environmental case. MC Mehta versus Union of India, 1988. Absolute liability principle. You cannot pollute the water bodies. Environment hiding here, because environmental PAL, social PALs, welfare PALs, understanding or not. Then last, electoral reform PALs. Electoral reform PALs means, we know the best organization is ADR. ADR, Association for Democratic Reforms, was Union of 2002 case. Compulsory, every voter has the right to know the information of the candidate. So affidavits have to be written, spouse qualification, your qualification, income, education qualifications, as well as your income vagera of you and the spouse have to be compulsory be there, including the criminal records. This, okay, it is one. PUCL versus Union of India, 2013 nota. Okay, this is also electoral reform. PIL has been filed. Okay, so ఇది రాయొచ్చు, హుసేనారా ఖాతున్ రాయొచ్చు, ఎన్వైరన్మెంట్లో ఎంసీ మెహతా రాయొచ్చు. Okay, all these are different dimensions: social welfare, social justice, and then we have environmental PILs, and then we have the electoral reform PILs. Once you write the side reading and the concerned cases and one line explanation, you have already told the significance of PILs. Now next, last part of the question. What is the last part of the question? Challenges. Okay, challenges emunna ikkada, all of us know. Frivolous means what? Unnecessarily public interest పోయి publicity interest అయిపోయింది అనమాట. So Supreme Court also commented on this. PILs have become publicity interest litigations. So you can use in the criticism part here that PILs, despite their significance in bringing reforms and protecting rights, has been met with criticisms as follows. Then first criticism is that it is frivolous litigations, frivolous PILs. Okay, second one is what? There is lack of any mechanism to enforce many times. Okay, that means follow-ups are not there many times. I'll tell you, all the environment PILs are there, but still action is not being taken. Pollution is going on, deforestation is going on. TN Godavar man judgment, there the court has told ki if something is forest, whether it is owned by the private or the public, doesn't matter. Forest means you have to save. But now it is no protections are there for the forests which are controlled by the privates. That means despite PILs are coming, the enforceability mechanisms are not there. Okay, lack of enforceability mechanisms. That is one more case for the PILs. And third one is, you can also use as Supreme Court itself has told that many PILs, Central Vista project, they asked to cancel. Okay, by citing some environmental cases. Supreme Court told that many times these PILs are being filed to stop the development and infrastructural projects. Okay, so you can say here delay, or it may affect the developmental. అంటే మనం దీన్ని అగ్రి అవ్వకున్నా కూడా ఆన్సర్ రాయాలి, జాబ్ కావాలి కదా, so రాయాల్సిన point. Okay, because even I was also supporting that, but we can understand. Okay, of course there are some people who unnecessarily file PILs to stop the construction of any projects, developmental or infrastructural projects. And you can say Supreme Court dismissed the PIL to stop the Central Vista project. Already now Parliament is there. Parliament ippudu undi kada, that is Central Vista project. When it was being brought, people filed PILs to stop it because cutting of trees was a part of Central Vista. Okay, so Supreme Court told we cannot, it's a motivated PIL. Supreme Court has told it's a motivated PIL, they have told. Okay, fourth one, mostly it is against government. It mostly PILs are filed against the government authorities, and private authorities are usually kept out of it. Okay, misuse, frivolous PIL. One more last point. Excellent point. Okay, that is overburdening of judiciary, and there you can write it may increase judicial activism. Okay, judicial activism and overreach also. Threats are there and చెప్పేసి రాయొచ్చు. Okay, that is the criticism. conclusion summary of the previous whatever you have written summary రాయాలన్నమాట అక్కడ summary అంటే I don't know, once after writing this much of content your conclusion is should be not completely out of tune with the what you have written in the top. Your conclusion should always be a kind of summary of what you have written in the top. What do you want to conclude here? PALs have been effective tool in the objective of what we wrote. No, those subheadings headings mentioned cheyali. However, there has been concerns of misuse or abuse of PILs of late. Hence, it is important to observe Supreme Court guidelines on PILs. Supreme Court already gave guidelines on PIL. No, it is important to effectively enforce the guidelines given by Supreme Court. They told in these cases don't come, only in these cases come, we just discuss. No, avi effective ga enforce cheyalani cheppesi rayali point. That is the last conclusion part. Chalo, last question guys. I think today we increased 7:30 avutundi. Last is what? Very interesting question. Tribunals. The use of tribunals. Any comments? Extra burden on courts, slows down development. Yes. Public health ban on crackers, safety ban on gutka. That is a good example. Okay, yeah, good, fine. Now, last question. The use of tribunals to deliver justice is beneficial, but it comes with multiple challenges. Analyze. Not much directives are there in this question. Straightforward question. Start your answer with what are tribunals? Tribunals are what, guys? Anyway, you can start either by saying quasi judicial, you can say, or you can say specialized legal bodies, you can say. Anything is accepted, guys. Adi veru. ADRs means here arbitration, conciliation, mediation. Okay, that is ADR mechanisms. Ante iddaru case fight cheste ala కోర్టులో కేసు ఫైట్ చేయకండి, గో అండ్ కాంప్రమైజ్ అన్నట్టుగా some mediator is there. No, that is called ADR. Lok adalats are considered as mechanisms of ADRs. These are specialized cases because here we are saying that a person who knows environment should solve environmental cases. A person who knows administration should solve administration cases. A person who knows the geology or hydrology should solve the water disputes. That means specialized bodies. Okay, legal bodies, or as you have told, quasi judicial bodies. Now, what is other keyword here, guys? Which has members of what? Judicial as well as experts. Specialized experts are there. This should be there in your answer because your introduction is kind of defining what is tribunals. Done. Now you can give some facts. Tribunals were not mentioned in the original constitution. They have been added by. If you want to skip the sentences, feel free to skip the sentences and just write phrase introduced by this amendment under articles 323A and article 323B, and here you can write administrative tribunals. Here you can write other tribunals. Chalu. Now, two dimensions. First one is what is the utility of tribunals, and next one is what is the criticism of tribunals. Both things you have to write here because the question is asking about it is beneficial but has challenges. Sorry, criticism about challenges. How it is beneficial? The tribunals are considered tribunals are essential in cases where specialization is required and JPSC hyphen in cases like environment, administration, labor, okay, taxation. ఇవన్నీ కదా, వీటన్నిటిలో we need specialization. Okay, అని చెప్పేసి they are helpful or beneficial in the following ways, and here you can write the points of where it helps. So first point, how tribunals are helpful. One thing is that same, it has experts, okay, who will be able to bring their expertise in solving the issues. It will reduce the burden on the judiciary. Okay, it reduces judicial burden because we are able to take up the cases proactively. Okay, third one more point. Tribunals లో ఇంకో అడ్వాంటేజ్ ఏంటంటే రీచ్ ఫైనల్ అని ఇస్తారు కానీ అది ఫైనల్ కాదు. No, that is also one more point. ట్రిబ్యునల్స్లో స్పీడీ అంటే ఐ హ్యావ్ ఫన్నీగా ఉంది, ఎందుకంటే ఐ హ్యావ్ స్టాటిస్టిక్స్ ఫర్ బోత్. Like when I say it is helpful for reducing burden, but there is also a concern that these days there is a lot of pendency of cases and JPSC kuda undi. If I say they are having experts, but criticism is that many times there are vacancies in the in the tribunals. So this is that answer where these two are kind of overlapping, what the good things as well as the bad things. I think that's what I also gave in my final answer. Just took a second. I mean, I will see just if something else I have added in my answer. Yeah, I gave the recommendations of 272nd Law Commission as the suggestions, but they are also related with this. I think I will have to change my answer. The use of tribunals to deliver justice is beneficial, but it comes with challenges. Okay, fine. So in my answer I added third dimension in the end. I gave at least some 6 to 7 points on 272nd Law Commission recommendations. I think you can add subheading there, value addition. And way forward laga raskochu. అర్థమైంది పాయింట్. అంటే క్వశ్చన్లో దే డింట్ ఆస్క్ అబౌట్ ఎనీ కైండ్ ఆఫ్ మెజర్స్ టు రిఫార్మ్, బట్ ఇన్ మై ఆన్సర్ ఐ హ్యావ్ గివెన్ ఆల్ దీస్ పాయింట్స్. సో ఎక్కువగా ఇందులో ఏంటంటే అదే క్రిటిసిజమ్స్ ఎక్కువ ఉన్నాయి నా పాయింట్స్లో, బికాస్ దే ఆర్ కన్సిడర్డ్ యాజ్ బెనిఫిషియల్ బట్ దే ఆర్ కమింగ్ విత్ మల్టిపుల్ ఛాలెంజెస్. సరే, బెనిఫిషియల్స్ ఒక 2 రాసాం మన పాయింట్స్. ఇంకో పాయింట్ ఏం రాయొచ్చు అంటే సేమ్ దే సి ద అడ్వాంటేజ్ ఈస్ దట్ రీజనల్ బెంచెస్, దట్ మీన్స్ every place, this is not there in this points what I'm writing on the board are not there in the notes, guys. Regional benches ante entante like Central Administrative Tribunal is there, CAT is there, it has at least 18 regional benches are there, which means access to justice is one more point which you can write. Sorry, the question is mostly focused on challenges kabatti. However, tribunals have met with the following challenges. Here you can play kabaddi, kho-kho, whatever. First things first, tribunals law majority of the appointments are done by the executive. So here what happens is it undermines the separation of powers, because generally, guys, collegium mein pura ka pura it's judiciary who is taking the entire credit, but in the tribunals what is happening is, like we should say NGT or CAT or any other tribunals, it is the government which is the major appointing authority, and government is a major litigant also in these cases. When the same litigant is appointing the judges or the members of tribunals, what happens here? It undermines the separation of powers. That is one thing. Second thing is it creates conflict of interest. Same person who is appointed by the executive will have to deliver the decisions against the executive. Conflict of interest, separation of powers, and also we can say it undermines the judiciary here. Undermines judiciary here. Why it undermines judiciary? Once you are saying, I don't know, same points here are becoming opposite also. Why it undermines judiciary? Because I remember there is one National Company Tribunal is there. No, National Company Tribunal is there. It adjudicates cases of companies. We have Companies Act 2013. If you have any appeal against National Companies Tribunal, it goes to what? NCLAT, which means National Company Law Appellate Tribunal. And you know what they have done in this Companies Act, no, section 423 and TSPSC Act chesi, they told that once National Company Law Tribunal, when it gives a decision, it goes to Appellate Tribunal. From Appellate Tribunal it will go to Supreme Court and rasaru. So here what is happening? You're undermining whom here? High Court you're undermining. So I think I gave the example in my answer. If not, you can remember NCLAT decisions are appealed to only Supreme Court. Now this, despite L. Chandrakumar case, Union of India 1997 case has told that tribunal decisions should be reviewed compulsory అని చెప్పారు. అయినా కూడా many of the laws which are there, no, they are undermining the powers of the High Court here. One more thing is, as you must have seen my Instagram, so environmental cases లో యాక్టివ్గా ఉంటాం మేము. ఓకే, సో ఇప్పుడు కేసీఆర్ వాజ్ ట్రైంగ్ టు డీవాటర్ ద హుసేన్ సాగర్ అవ్వచ్చు, ఇలాంటివి కొన్ని ఉన్నాయి. Or saving of Nayakila అవ్వచ్చు. Just Google Nayakila and my name, you'll get the cases and all that. So NGT is there. NGT is National Green Tribunal. National Green Tribunal is supposed to adjudicate on the issues of the environmental laws. But benches kitne hain? Delhi is the principal sitting of NGT. Then we have Bhopal. Okay, then we have Kolkata is there. Chennai is there, Pune is there, Hyderabad is not there. So our madam always has to go to Chennai and file all the cases, hearings, meetings, and so access is little bit restricted or not. So you can write some tribunals are having less, we can say less regional benches. Access to justice is a problem also here, guys. Access to justice, lack of regional benches. Example, NGT has only 5. No, Delhi is there, Bhopal, Kolkata, and then you have Pune and Chennai. That's it. We don't have everywhere. Even though if it is better if they have this particular benches, as 272nd Law Commission has told that wherever high courts are there, nearby appoint the benches. That is their recommendation. I will discuss that. Okay, that is one point there. And tribunals link points, challenges law, vacancies చాలా ఎక్కువగా ఉన్నాయి. Many times judges are not appointed in these tribunals. Pendency, last time I checked, I think there was some 91,000 cases pending. That year exactly I'm forgetting. 15 comments. Oh my god, ఏంటండి duplication of cases. Okay, suddenly. Okay, overlapping jurisdiction. Okay, fine. Yes, no uniform conditions in recruitments. Traditional courts average 6 points. You're talking about extra layer of litigation, service conditions, lack of uniformity, duplication of cases, overlapping of jurisdiction. Okay, good. Fine, I take the points. That is the point which we have to study in this things. Okay, fine. Or यहाँ पे क्या है? Other points, vacancies also over. 6 point add చేద్దాం ఇంకోటి. Overlapping jurisdiction kind of we can add separately also, but here also okay, ఇక్కడ appeals లేవు కాబట్టి అది add చేయొచ్చు. No criteria for appointments. Inkoti, one more point is that they don't follow the usual procedures what the courts follow. They follow the procedure of natural justice like NGT are there, no, but which are not well defined. So it means arbitrary, or we can say not well defined criteria is there for adjudicating of cases. Ante kada. మామూలుగా ఉండే కేసెస్ ఏం చేస్తే అంటే దే విల్ ఫాలో ద ప్రాపర్ ఇండియన్ ఎవిడెన్స్ యాక్ట్ ఇస్ దేర్, దే విల్ ఫాలో ద కోడ్ ఆఫ్ సివిల్ ప్రొసీజర్, క్రిమినల్ ప్రొసీజర్ కోడ్ దే విల్ ఫాలో, బట్ ట్రిబ్యునల్స్ సమ్టైమ్స్ ఆర్ ఎగ్జెంప్టెడ్ ఫ్రమ్ ఫాలో దోస్. దే కెన్ ఫాలో న్యాచురల్ జస్టిస్ ప్రిన్సిపల్స్. సో ల్యాక్ ఆఫ్ యూనిఫార్మిటీ ఇన్ అప్లికేషన్ ఆఫ్ లాస్ చాలా అయిపోయినాయి. ఓకే, ల్యాక్ ఆఫ్ యూనిఫార్మిటీ ఆఫ్ అప్లికేషన్ ఆఫ్ లాస్. క్వశ్చన్ यहाँ तक डन. Okay, it's done. 2 minutes. Suggestions and way forward you can write. To overcome these challenges, 272nd Law Commission has recommended the following and cheppesi rayachchu. What they have told is, whenever you feel some vacancies are going to happen within 6 months time period lo I gave in the answer. Okay, model answer 6 months lopala em cheyalante vacancies ni fill up cheseyali. And second point, there should be a proper recruitment conditions, as the person has pointed out. Okay, there is no conditions, there is no proper criteria for or qualifications for many of the posts. Many times experts are appointed without proper criteria also. So we can say standardization of the appointments, having a proper criteria for the recruitments, that is also one point. Not my point, it is like Law Commission recommendations. Second point. Okay, third point, what Law Commission also is saying that we need to give training for all these tribunal experts and the members. Why? Because if you give training for all these people, they will be able to have the legal competence to solve all the issues. Many times without having information about India's laws, in the tribunals they are not able to give the right decisions. So there should be a standard training procedures and providing good training and skills for these people, so that they will be aware of the legal implications or the legal aspects of India. That is one more point. Okay, Inka, these how many are over? 3 or 4 points. Law Commission. Apart from this, they also explored the idea of having an independent body which can make the selection process of this. Ante selection criteria koncham executive nunchi delineate cheyadaniki they have proposed to establish some independent body. Ante of course Law Commission is just advisory body, they will not be able to impose any conditions as such, but they recommended that why can't we have an independent body with a proper panel which will select all these members of the tribunals. So ilanti oka 4-5 points raste suggestions lo manaku help avutundi. And what criticism I told that benches are not there, no. So Law Commission told that wherever in India high courts are there, in the nearby vicinity establish the regional benches of the tribunals so that people can access those things easily. Now that is why, guys, before I end, there is one demand of having regional benches of Supreme Court also. Okay, and there is one more demand of having National Court of Appeal also. Why these two demands? One thing is I have to always go to Supreme Court in Delhi. Okay, as per Article 130, the seat of Supreme Court is Delhi only. So that means now nobody in India can force CGI to have another thing. But some people are asking for having regional benches, or to reduce the burden of the Supreme Court, let us make it like America. In America, what happens? Only constitutional cases can be appealed in the Supreme Court of USA. Why can't we make the same in India? And let us establish National Court of Appeals in different cities, metropolitan cities of India. For civil cases, criminal cases, rape, murder, property, whatever, no need to go to Supreme Court. Go to these regional National Court of Appeals, NCAs. If there is any substantial constitutional law or constitutional interpretation required, then you have to go to the Supreme Court. Unconnected some point, but please remember these points, because I have not had a question of NCA. But if you are writing UPSC or something, please do read about National Court of Appeal. చదవండి, అది నేను ఇవ్వాల్సింది యాక్చువల్లీ నోట్స్ అది రోజు క్వశ్చన్స్లో ఇవ్వలేదు. నేషనల్ కోర్ట్ ఆఫ్ అపీల్ నాట్ వెరీ ఇంపార్టెంట్, బట్ న్యూస్లో ఉంది. In USA, only in constitutional cases appeal lies to US Supreme Court. In India, all cases can go to Supreme Court. Appellate jurisdiction is there, no? Constitutional, civil and criminal cases 132, 131, 132, 133, 134 are there, no articles. That is one thing. Tribunals, maybe Law Commission has told to give accessibility for people to tribunals. In every High Court jurisdiction, appoint one tribunals. So this is the Law Commission recommendations. Done, guys. Class. Okay, guys, I will take a leave. Tomorrow is last chapter for us.